Our top story tonight, the Oklahoma Supreme Court has blocked St. Isidore Catholic School from becoming the nation's first religious charter school. The court says that the state school board's narrow approval last year violated the Establishment Clause that prohibits the government from making any law respecting an establishment of religion. One justice said, quote, "Under Oklahoma law, a charter school is a public school. As such, a charter school must be non-sectarian. Legal challenges are expected, and the case could come before the nation's highest court." All right, let's bring in Rick Garnett, professor of law and director of the Notre Dame Program on Church, State, and Society. Rick, thanks so much for coming back. We appreciate it. So what is your reaction to the court's ruling today and its interpretation of the Establishment Clause?
Well, the ruling's a disappointment. The court, with all due respect, got it wrong in at least three different ways. So first, the Oklahoma court interpreted its own state constitution to require discrimination against St. Isidore. And this runs squarely contrary to Supreme Court precedent from just a couple of years ago, a big case called Carson versus Macon, where the Supreme Court said states are not allowed to use their own law as an excuse for discriminating against religion. And that's what the Oklahoma Supreme Court has ratified here. The Oklahoma law has permitted funds to go to religiously sponsored institutions in some instances in the past, but not here. And it permits all kinds of nonprofits and indeed for-profits to run charter schools, but it's singling out St. Isidore for exclusion. So that's wrong. They're also wrong when they characterize St. Isidore as a state-run school. It just isn't. It's a school that the Oklahoma is contracting with in the same way that, local cities often contract with private folks to pick up the trash, and that doesn't make St. Isidore as part of the government. So, the Oklahoma court got the Establishment Clause wrong on that one as well. And then finally, the court suggested that the federal Establishment Clause doesn't permit local governments to engage in contracts for public services with religious institutions. And we just know that's false. I mean, public funds have been used at religiously affiliated schools, universities, hospitals for decades. So it was kind of a three strikes and you're out as far as I'm concerned for this ruling.
Yeah, Rick, and one of your colleagues at Notre Dame, John Miser, has been quoted as saying, in part, this is unconstitutional discrimination against religious educators, that is, and the children they serve. Would you agree? How do you see this?
Well, I certainly agree, and John is one of the lawyers who's on the case. I'm not. I'm commenting only as an observer. But John and his team of our students were actually participating and helping to represent St. Isidore's position in this. And I think John hits it on the head. I mean, Oklahoma has a program, a charter school program, that permits all kinds of entities to submit proposals for charter schools. St. Isidore was one of them, and the proposal they submitted was excellent. It qualified in all other respects. There's been a great deal of interest. Hundreds of children have expressed interest in attending this school, which would serve a lot of, frankly, underprivileged kids who aren't always getting the services they need. And for no other reason other than the fact that St. Isidore is meaningfully and distinctively Catholic, it's being excluded. It qualifies in every other respect. And again, this is not a form of discrimination that's required by the separation of church and state. Our Constitution and Oklahoma's Constitution, correctly understood, permit these kind of cooperative arrangements. St. Isidore wouldn't involve the establishment of a state religion. It would just mean giving parents and kids more options, and it's their choice whether they choose to attend this school or not. So again, a disappointing ruling. I hope that on appeal or further review, it's turned around, because I think school choice is proving in our day to be a really effective engine for educational reform and increased opportunity.
Yeah, really quickly before I let you go, can you talk about what comes next, and do you think this could potentially end up at the Supreme Court?
Well, it's a legal question that certainly could. Whether it does in this case or not, I really can't say. I want to defer to those who are actually representing on the case. But the question presented here, namely whether the Supreme Court would retreat from this non-discrimination rule that it's been so clear on these past few years, that's one that I think they'd want to address. And my prediction is that the Supreme Court would say that the Oklahoma court got it wrong.
All right, we're going to leave it right there. Rick, great to be with you. Thank you so much. God bless.
Thank you.